matter of the jail officer and the supervisor.
Yes, Miss Kilroy.
My lord, I appear on behalf of the appellant, together with Mr. Henderson, Mr. Alistair Henderson, and my learned friend, Mr. Harland,
Yes.
appears on behalf of the Secretary of State.
Yes.
I realise there's quite a bit of housekeeping that I ought to do before I begin.
Yes.
And
Where in the amended appellant's notice is there an attack on the Rule 43 decision? And where is the question of jurisdiction raised, either in an appellant's notice or in a respondent's notice? What are we here to decide? When I read the papers on Friday, I was completely baffled about what this appeal was about. I spent quite a long time reading a completely redundant core bundle, which the notice of appeal suggested I should be reading. So this appeal, I'm sorry to say, is in a complete mess.
well, my lord, I accept that the way in which the papers are structured does not explain the passage of this appeal, which has been unusual because it was stayed behind, or at least it was held behind the decision of the tribunal in EP Albania, and so.
Well, let me say that I had no idea from reading the papers that your client had anything to do with EP Albania. It was completely unexplained.
Well, my lord, may I start by saying what I hope has become subsequently apparent, notwithstanding, unfortunately, how it began, is that the bundle that is now relevant is the supplementary bundle, Part 2,
Yes.
which contains all the materials.
Eventually I got there.
And I apologise.
This court is not here to give advisory opinions. It is here to resolve disputes. And disputes are raised before this court by way of an appellant's notice and respondent's notice, both of which are lacking.
Well, my lord, I absolutely accept it. And indeed, I hope you've seen from the appellant's note of issues that that's the appellant's position. Jurisdiction was not raised in this case.
Right.
Because
it was on page 83 of Supplemental Bundle 2, which Mrs. Lady Justice Elizabeth Lane granted you permission to. If you look at those
Yes.
acting for it, says, in the light of those developments, the appellant seeks the court permission to amend his appeal notice pursuant to, and then the rules are set out, to plead the following grounds: 4, 5 and 6 plainly engage EP Albania.
Yes.
And when you were directed yesterday to put in the notice of the notice of appeal, it might have been thought that that was what was going to come back, because that was what you had asked and got permission to appeal from Lady Justice Lane on.
Well, the appellant's notice does say that we challenge EP Albania.
Where?
It's an amendment to.
New ground 4 is the UT acted unlawfully in deciding the asylum appeal without a hearing. Well, that's the original decision. That's not anything to do with UT Act.
Yes. Well, my
And
lord.
then the ground 5 is the UT was wrong to treat the appellant's consent to a paper determination. Now, is that supposed to be UTAC?
Well, it's UTAC is what heard both the original appeal and the appeal and the EP Albania set-aside application.
But there were two separate decisions, and there is between you, it seems, an issue as whether there is jurisdiction to hear the appeal in relation to the second part. And that was what you had fairly raised in your proposed amended grounds, which Lady Justice Elizabeth Lane mistakenly thought would lead to the amendment. And when the parties couldn't agree matters, I gave the direction, well, put in your skeletons on this, rather hoping, or perhaps expecting naively, that things might get resolved. They didn't. But you got permission on a basis which I appreciate it wasn't you, but on a basis which was that you must take these grounds of appeal. We're going to amend to put them in, and you haven't amended to put them in.
Well, I accept that. Can I just show you in the section 5 of the appellant's notice that there is an amendment?
Is this what we got yesterday?
Yes.
Yeah.
So, and at the end of the upper tribunal's determination promulgated on 24th of August, and the refusal of the upper tribunal to set this aside in EP Albania.
Sorry, where's that?
Well, I hope that you've got the right one. So in section 5, it says, please set out the order or part of the order you wish to appeal against.
Wait a minute. Yes, right.
So that's the amendment.
Yeah.
My lord, I accept ground 4 has always been and has always been stated to be aimed at the original decision, because the original decision is obviously the one that decided to dispense with the oral hearing.
Yeah.
But it implicitly engaged the decision of EP Albania because EP Albania refused to set it aside on that basis. So in EP Albania,
We shouldn't be guessing what grounds of appeal are supposed to engage.
Well, I understand. It is clear from the skeleton. I mean, the skeleton argument was amended, my lord.
Yeah.
The skeleton argument was amended to explain,
Yes,
to
I
incorporate the two. I accept that, of course, having applied to add the grounds, they should have been added to the formal appellant's notice. I accept that, and I apologise for it. But the skeleton argument was amended, and it does explain the relationship between ground 4, ground 5 and EP Albania. And so it is there, it is pleaded. It's just that there wasn't a formal amendment, which I apologise for, and I can only do that. But I realise that it's left things in a state of unclarity. But what I can say is that the jurisdiction, the application was made, as my Lord Justice Dingemans has said, to amend, to challenge EP Albania. No one had raised, the Secretary of State had not raised a jurisdiction issue at any point. The jurisdiction issue, as Your Lordship has pointed out, has not been raised by way of a respondent's notice. And in the note of issues that we submitted last week, we have, and in a letter to the Secretary of State which accompanied it, we have squarely said to the Secretary of State, based on our skeleton argument on jurisdiction, we don't really understand what the dispute between us is about, because we are saying, which is why we didn't raise a jurisdiction issue, that it doesn't matter whether you have a separate independent right of appeal against the decision to set aside, because on any view, if you don't have such an independent right, it would be because of the regulation that my learned friend is relying on. In other words, the abbreviation is IDO, but the Appeals Excluded Decisions Order, which would make it a procedural, ancillary and preliminary decision. And it's beyond argument, in my respectful submission, that this court, on hearing a substantive appeal, can consider relevant reasoning, or operative reasoning, I should say, in a preliminary, procedural or preliminary decision. So we would be talking about the decision of EP Albania in this appeal and deciding whether it was correct or not.
Why?
Well, because it's part of the reasoning of the upper tribunal as to why they decided that dispensing with an oral hearing was appropriate in the first place, and why they refused to set it aside, which is part of the course of this appeal. I mean, it's the upper tribunal's reasoning.
So you are appealing against the decision that they ended up with. You're not saying that we've got to decide the point that the Secretary of State wishes us to decide,
On jurisdiction.
which is whether or not this court has jurisdiction to entertain any attack upon the exercise of Rule 43 by the upper tribunal.
Well, we say that's not necessary because
Yes,
we
but
say...
do you agree with the Secretary of State's submissions that you cannot appeal...
No, we don't agree with
Well,
that.
just...
Sorry, I do apologise.
Yes. That you cannot appeal per se
Yes.
against the fact that the upper tribunal decides to exercise its Rule 43 power to set aside or not. What you do appeal against is the substance of the decision that's left at the end of the exercise of that discretion.
Yes.
Do you agree with that proposal?
We do not agree that this court, on an appeal against the substance of the original decision, does not also examine the Rule 43 decision and decide whether it's correctly decided or not.
But why do they need to? What they're being asked to do is to look, as you say, at the substance of whether or not there was fairness in dealing with the application on the papers.
Yes.
That's what you're asking. You're not saying, well, this court has got to say that the upper tribunal exercised the wrong power in setting aside. You're going back to the decision, which is what the Secretary of State is saying.
Well, my lord, my lady, I do accept that it is possible, as a matter of theory, because the attack, the thing that matters is the substantive appeal. That's the thing that needs to be set aside. And whether my learned friend is right or wrong, that gets set aside. And there's then, as you will have gathered from the papers, there's a cost dispute, which is why that's why we're here at all, is that there is a cost dispute, because the Secretary of State is saying that they will only pay for the costs of the substantive appeal, even though they've agreed that it should have been effectively set aside. So but I accept that you.
Sorry to interrupt. Can I just say I know what the shape of the cost appeal is? So the real issue between you is whether you should have your costs of the EP Albania hearing. Is that
Yes.
right? Yeah. Okay. I had inferred that, but I just wanted it confirmed.
Well, the Secretary of State has offered to pay costs of it's clear in the correspondence, has offered to pay costs, but not of the EP Albania.
In which case, you do need to show us that we have jurisdiction to hear an appeal against the EP Albania.
Well, I say I don't. I say that I can. That there are two. The Secretary of State's argument is that you don't have jurisdiction because it is a procedural, ancillary, and preliminary decision. Yeah. And I say that if the Secretary of State is right about that, then it is obviously bundled up in the proceedings of the upper tribunal, which the Secretary of State has accepted now on this appeal, were wrongly decided and need to be set aside. So the decision.
May I ask, did you apply for costs in EP Albania?
No, I mean, the costs were long. I mean, first of all, in the upper tribunal, you don't normally get your costs at the end of the appeal.
Did anybody apply for costs in EP Albania?
No, cost is not. So first of all, we didn't apply for costs because we'd lost.
You lost, yes.
But costs is not normally awarded except in exceptional cases.
So this is an appeal to determine an issue of costs, and we've got to devise that from questioning of you this morning, because there's nothing in the skeleton that points this out.
My lady, first of all, I do apologise. We did try to explain what issues were before the court in our note of issues.
But you've been very upfront about it, and said this is all about costs.
Well,
this is really all about costs.
Well, that is the only dispute between the parties that is left. That is that in which there is a substantive issue. Yes, I accept that. It's about costs, and the Secretary of State had. I mean, this has come on in it came on quite fast, this appeal. The Secretary of State didn't put in their skeleton argument, having asked for extensions, until the 29th of June. It was only apparent then that the Secretary of State was not opposing the appeal on any of the grounds. It wasn't clear until that point that the Secretary of State was not opposing the appeal on grounds 4 and 5 as a matter of substance, and was not saying that you couldn't consider the EP Albania arguments, because that's the other issue here, is whether you can consider if the tribunal has correctly decided EP Albania or not. And it wasn't clear that what the Secretary of State's position was until the skeleton argument came. And in the skeleton argument, the only thing that the Secretary of State has addressed is the issue of jurisdiction to challenge the Rule 43 decision separately.
Well, that's true, but on the other hand, you didn't provide us, and as far as I know, still haven't provided us with a copy of EP Albania, which is the decision you want to attack.
I think we tried to do that yesterday.
You may have. I think Mr. Henderson said he'd bring one along this morning.
I see.
Well, if you want to appeal against a decision, it's normal, to say the least, to provide the appeal court with a decision that you want to attack, which you didn't.
It should have been included.
It should have been.
It should
Of
have
course
been
it should have
included.
been. And there should have been proper grounds of appeal.
Yes, I accept that. I accept it. I accept it should have been in the bundle.
So we're supposed to decide this, are we, substantively? You say it doesn't matter whether we've got an independent jurisdiction to hear the appeal. It's all part of the main appeal.
Yes.
So don't we need to look at EP Albania?
Well, you do accept that the Secretary of State. It's now clear that the Secretary of State is conceding that
He's not conceding setting aside EP Albania.
Well, I think the Secretary of State really needs to explain what her, because I am also not clear what the Secretary of State's position is on this case. It's not clear to me whether the Secretary of State is saying that Lady Justice Elizabeth Lang should not have granted permission on those grounds. It's not clear to me whether the Secretary of State is saying we can't look at whether EP Albania is correctly decided or not, because that, of course, raises quite significant issues, bearing in mind, and my Lord Justice Dingemans will be well aware of this, EP Albania was supposed to provide guidance for other cases about how the tribunal would approach its set-aside power. So the question of whether it is correctly approaching that issue is a really important issue that needs to be amenable to some sort of challenge. And so my primary submission is, of course, it's amenable to challenge in most cases via the substantive appeal, because in substantive appeals, you will always look at the full reasoning of the tribunal, including reasoning on permission to appeal, for example.
But EP Albania covers 18 cases.
Yes.
And so where in Section 5 of your amended Notice of Appeal do we understand from the amendment that this is to do with the principle that is to be obtained from EP Albania, rather than, as it is said, the order which you wish to appeal against is the Upper Tribunal's determination promulgated on 24th August 2020 dismissing the appeal against the determination of the First Tier Tribunal. That much is clear. That was in the substantive grounds as to the mistakes that had been made and then endorsed by the Upper Tribunal. And then it goes on, and the refusal of the Upper Tribunal to set this aside.
Yes.
Now, that goes to your substantive appeal, not to any grounds attacking the principle to be derived from Albania, which is a one-size-doesn't-fit-all.
Well, that's dealt with in the grounds of appeal now, as amended.
Well, where?
At grounds 4 and 5.
Well, this is what we started with,
and it's also dealt with in the skeleton argument.
Well, before we get to the skeleton argument, these grounds of appeal that we received yesterday as amended appear to be the only amendment that's been made since the 17th of March.
Well,
because it's the only amendment shown in red. If you'd further amended, we'd be on to green and no doubt the other colours of the rainbow by now. So these were the only amendments that you've made. And you have to make the basis of your arguments in a skeleton argument. The skeleton argument, in accordance with Practice Direction 52, refines and confines and helps the court to understand your arguments.
yes.
But apart from the substantive arguments that you make in your skeleton argument, there's no real digging down to where we get to this morning.
Well, my lord, my lady, the skeleton argument is dated the 18th of May 2022. So that does post-date and it was intended to, the grant of permission.
Now,
So
the point
this is
my
bundle
lady's-
page
the point my lady's putting
Yes.
to you is that the skeleton argument is meant to support the grounds of appeal.
My lord, I don't know, I do apologise, I'm getting all my addresses wrong this morning. I absolutely accept that there is a mistake that has been made in not amending the appellant's notice and the grounds. But in my respectful submission, putting to one side the lack of clarity that there is before the court, an application was made to amend. That was clear, which was determined on the papers by Lady Justice Elizabeth Lang. The skeleton was then amended. It is not in my respectful submission, a substantive problem. It is a problem that I accept of not complying with the procedural.
There is
the
no
procedural
ground of appeal before us, even though we asked yesterday for the deficiencies to be rectified, and the application that my Lord Justice Dingemans took you to, page 83, supplemental bundle 2, indicates how it is desired to amend the grounds of appeal, but no such amendment was made once leave had been given.
Yes.
So it's not for this court to assume that you want to continue with every single point that you've raised. It's not for this court to wade through the correspondence that has been provided to determine what the dispute is between you.
Well, my lady, with respect, the skeleton argument that was subsequently amended does make clear that that the appellant wishes
The
to pursue.
subsequent amendment to the skeleton argument, Miss Kilroy, is no proper basis to make an argument that is not contained in the grounds of appeal.
My lady, I accept that, and I'm
But
applying
even now,
yes, but
even now, given the opportunity yesterday, we're still at sea.
But my lady, on that, I'm not sure that I fully understand that, because the grounds have been amended as foreseen now, late, and I absolutely accept that, but as foreseen by this application in the original
No,
skeleton.
it doesn't foresee it. The application made at page 83 is not foreseen by what we see. Now, 2 grounds.
Well, that's because they were only permission was only granted on those 2 grounds.
Well,
Lady Justice Elizabeth Lang.
Where do we find the order of Lady Elizabeth Lang giving permission to amend
I
your
think it's 78.
It's at
isn't it?
75.
of supplemental bundle 2?
2.
Yeah.
Yes.
Right, so 4 is that the UT Act misunderstood JCWI. That doesn't make it into the amended notice of amended appellant's notice.
Yeah, because we didn't. The grant of permission was only. If you look at page 79 to 80, you'll see under the heading of fairness there were a range of grounds that were advanced.
So we're looking at page
79 under the heading of fairness, paragraph 23. I hope I've got the right under number.
79. Right.
So, Lady Justice Elizabeth Lang sets out all the grounds.
This is 79 of supplemental bundle 2.
Yes, it should be.
Okay.
That's in the middle of her. It was a very long grant of permission, unusually so, in my respectful submission. And 79 is the bit that deals with the additional grounds that were for which permission was sought.
But at paragraph 26,
Yes.
Lady Justice Elizabeth Lang said the upper tribunal misunderstood and misapplied the decision in JCWI. That must be a reference to EP Albania, is that right? Is that the one she's referring to? When she says in paragraph 26, grounds 4 and 5 are arguable.
No, it's not. I'm afraid there's a confusion, and I made the same mistake myself. It's with the Roman numerals. It's, if you look at the very first round, it's Roman numeral 1 and Roman numeral 2. And then you'll see ground 4 in brackets at the end. That's what she's talking about at paragraph 26.
So grounds 4 and 5 are a reference to 1 and 2, is that right?
To 1 and 2, which are all 2 is about EP Albania, largely, although obviously there is a crossover because it was the original judge who may have been thought to treat consent as determinative, although we'll see that the reasoning was very brief.
And so it's those grounds, as Lady Justice Elizabeth Lane reformulated them, that are now put into your amended.
Yes.
Yeah.
Well, the UT was wrong to refuse to set aside the determination when the Secretary of State conceded that it should do so. That's on the basis of them refusing to act pursuant to Rule 43, is it?
I'm sorry, that is ground 8, and permission was not granted on any of those grounds.
Yeah, that's the next point. So
No.
that appears to be the attack upon the UT for failing to exercise its power to set aside under Rule 43. Is that right?
Well,
We are having to go on the determination of my Lady Justice Elizabeth Lang rather than upon your appeal notices and grounds of appeal, and that cannot be a satisfactory state of affairs, Miss Kilroy.
well, my lord, my lady,
And there's been an opportunity to put this in order.
Well, my lady, I do submit that it has now been put in order, and if I might, it might assist if I developed and explained what the case was, because
Well, you
actually
might not
it
have
is.
needed to take so much time about it if the documents before the court had permitted it to know, as it was reading, sometimes unnecessarily,
Yes.
the documents contained haphazardly, if I may say so, in the different bundles. That which is in a supplementary bundle 2 should have been in a core bundle. There's been absolutely no regard had to anything that would resemble an efficacious application.
Well, my lady, I accept that the bundles should have been better organised, and I also accept that you could have been signposted to the bundles, and should have been, to the bundles that were now relevant in the light of events. I accept that.
A reading list might have been helpful. A reading list might have been
And
helpful.
a reading. I accept all of that. And I can only apologise again that it is not clear.
Can I just try and help before you go into the detail? Your revised ground 5, which,
Yes.
whatever it was of Lady Justice Elizabeth Lang's order, was one she granted permission for, does appear to engage the EP Albania point, which you fairly recognise by amending your notice of appeal to say you're also appealing against EP Albania. The Court of Appeal in MO sent out, I think it was a master's direction, that this court had no jurisdiction. Is that right? So your amended ground 5 now raises a point, regardless of whether the Secretary of State put in a respondent's notice or not, and the Secretary of State, as you fairly point out, got a lot of extensions and still hasn't put in a respondent's notice. But if there is a point of jurisdiction for the court, we need, regardless of what the Secretary of State's position, and you have perfectly fairly said it's not entirely clear what their position is, we still need to decide that, because if it's a point of jurisdiction, we have to determine it.
Well,
on your ground 5.
My lord, I accept that if this court does not have jurisdiction, if it is said that this court does not have jurisdiction to even consider the reasoning in EP Albania as part of the substantive appeal. But my argument is that there are 2 routes to considering the reasoning in EP Albania. Route 1 is the entirely conventional route, that when you're looking at the proceedings before a tribunal, you look at the whole reasoning that is applicable to the decisions that they have taken.
Can I just ask you to deal... I understand that point.
Yes.
And when you've got an error of law and then a remaking of decision, of course you're going to look at both hearings,
Yes.
otherwise you end up with all sorts of problems. But a way of looking at Rule 43, and
Yes.
this is to give you the opportunity to comment on that, is that it is a short, summary jurisdiction to put right obvious errors where the tribunal avoids us being overloaded with even more work. And therefore, you would never look at the reasoning because it was either right or it was wrong. And actually, we're interested in the error of law decision and any remaking rather than what anyone has decided in Rule 43.
I understand that, and I certainly agree that Rule 43 is supposed to allow the tribunal, there's no doubt about that, to swiftly correct serious errors so that this court is not troubled.
Well, one of the textbooks describes it as a quick and dirty method of putting things right. I mean, that may be a bit rude, but
Yes, so I certainly accept that, but we'll have to look at the structure of the Act in due course, but I don't accept that that means that you don't, when looking by either route, an independent right of appeal or the substantive right at what the tribunal has itself thought about the procedural irregularity that has been alleged. And in my respectful submission, it would be very surprising if this court didn't look at it via the original substantive appeal route in most cases, because it's likely that some of the reasoning of the tribunal is going to be relevant to the issues before you, and indeed we can see that it is relevant from the Hussein and GA judgment, because this court looked at the reasoning of the tribunal in EP Albania when approaching the question of fairness itself.
Well, assuming the court does look at the reasoning,
Yes.
why does it follow you get your costs?
Well,
That's what this appeal is about.
well, my lord, it follows that because it's part of the proceedings, but it's why we shouldn't get our costs is really the big issue. But
Well, one reason, as you told us, is you don't get your costs in the upper tribunal.
well, you do get your costs on appeal. So it is standard practice to get your costs of the tribunal proceedings when it goes to appeal. That's standard practice. So you don't get them in the tribunal, but you do get them if the Secretary of State opposes the appeal unsuccessfully in the Court of Appeal, or if it goes to appeal, basically. So that's normal. So, and you would then get your costs, common practice of the whole proceedings. So it's the Secretary of State who is doing something unusual in our submission, which is seeking to carve out a bit of the proceedings which she herself is saying are ancillary, procedural or preliminary, and say, well, we won't pay that. And we, on this side, the appellant is surprised by that position. It's not normal. And so it's the Secretary of State who is saying, because you don't have jurisdiction to consider this in the Court of Appeal, therefore, it's not necessary to pay costs. Right. That's as I understand it.
All right.
You were going to tell us your second route. The first route was we look at the whole reasoning.
The first route, I say, is wholly standard. The second route is the real nub of the reason why I think this court wanted to consider the jurisdiction issue, is that there is a question that may arise in some appeals, not this one, where for some reason it is not possible to appeal the substantive decision, and ordinarily that would be because of time limitation reasons. And so that is an issue that arises in another appeal called MO, because that appeal is out of time and an extension has been sought, but that's what's happening in that appeal. So then a question arises, is there a separate right of appeal anyway, even if an extension weren't granted, against the Rule 43 decision? So that's the other route by which this court might consider the Rule 43.
Right. Well, those are the two routes. All right. Thank you very much. Now, to sit down for a minute. Mr. Harland, why is there no respondent's notice?
My lord, I can only apologise. I haven't been involved with the procedure until recently, and I don't hide behind that. It's just I can't answer that question. It seems that we may have been overly responsive rather than proactive in seeking to respond to the case that was being...
Well, I suppose to be fair to you, until this morning, there's been no amendment, or till yesterday, there'd been no amendment to the grounds of appeal to raise anything in connection with the Rule 43 decision. But now that there has been, you'd better put in a respondent's notice, hadn't you, disputing jurisdiction?
My Lord, if the if permission to amend is granted, then...
Well, I think Lady Justice Elizabeth Lang granted permission to amend, it's just that it wasn't taken up until yesterday. I mean, we could treat this as an application for permission to amend, but I think that's already been decided.
Well,
and either grant it or refuse it, depending on whether we think we've got jurisdiction. But at the moment, speaking for myself, I think that permission to amend has been granted, and therefore you need to put in a respondent's notice if you want to take the jurisdictional point.
My Lord, yes, we can do that. The question is when.
As soon as you can.
Sorry, Lord?
As soon as you can.
Would it assist if we did that over the short adjournment? And we continue now to hear submissions.
Yeah.
Can I, whilst I'm on my feet, can I just raise this point in response to my learned friend, who says that this is really a cost issue? For our part, we don't accept that we're just here today to argue about costs. Had we thought that this was just going to be a question as to whether they get their costs of EP or not, we could clearly have dealt with that by way of written submissions if we couldn't agree. We would have argued, not least, that because they weren't entitled to their costs, and this is a point that my learned friend says it isn't open to us, but it clearly is, because they weren't entitled to their costs at the lower level, they shouldn't be entitled to them on appeal now. But that we could have dealt with that by way of written submissions. We're here today because of the point of principle.
No, I understand that.
And we do say that if there is a subsidiary route to appeal against the Rule 43 decision by itself and not against this decision in substance, then that is giving rise to a new route of appeal, which is just going to lead to a...
I understand the argument. I understand why you want the point of principle decided. Yes, Ms. Colway.
So, my Lord, the advantage, of course, of a respondent's notice would have been, which is that it would have clarified whether and I hope it will clarify, whether the Secretary of State is saying that this court cannot hear a challenge to the reasoning in EP Albania via Route 1. That is a very important issue on its own, and in my respectful submission, it's not argued at all, it's not dealt with in the skeleton on jurisdiction. All that the skeleton on jurisdiction deals with is whether there is a separate right of appeal in Rule 43. So, my Lord, what I was proposing to do in those circumstances, since there is at the moment, no contest in my respectful submission to the primary position of the appellant, which is that it doesn't matter because this court can consider it anyway as part of its ordinary substantive appeal jurisdiction. I was going to just look at the issue that is between the parties, which is in which the Secretary of State has advanced arguments, which is whether you can independently challenge a Rule 43 decision.
Can you remind me again why you'd want to do that?
Well, my lady, I don't want to do it. In fact, that's what the note of issue says. We've asked the Secretary of State.
I know, about this case, you've said you don't want to decide it, but why would you want to independently challenge a Rule 43 decision? What are the...
What my client does not need to and has...
No, I understand that, Miss Kilroy. But you're now going to go on to the jurisdictional point, which is, should there be able to be raised an argument that you cannot independently challenge a Rule 43 application? Do you say it cannot possibly exist outside a substantive decision?
My argument is that you can appeal by both routes when you look at the legislation. The reason this issue is...
I understand. Yes. But so can you tell me why you would need to independently challenge the Rule 43 determination? Yes. You gave an indication that in MO,
yes,
it was because the appeal was out of time.
Yes.
So on that basis, you'd be challenging the fact that the upper tribunal refused to go along the Rule 43 route.
Yes.
Regardless of whether or not there was a basis to do so, that it was in the interest of justice and one of the preconditions applied. So we're assuming, are we, that those preconditions or one of them will apply?
Yes. So you would be challenging the decision, the refusal to set aside the determination. You'd be in time to challenge that refusal on the basis alleged, which in all of these sequence of appeals is a refusal to hold an oral hearing. So it would be the tribunal was wrong.
But it's not just in the case of oral hearings, is it, that Rule 43 is utilised?
It could be any of those grounds.
So on the basis that a matter comes before this court where the tribunal has correctly identified that there is or is not the basis to exercise the power, you are saying that there's an independent right to challenge the exercise of the discretion, or what? If you're not going to the substance of the actual decision, but the independent right to challenge the making or otherwise of a set-aside.
Well, my lady, what your challenge? So perhaps let's just have a look, if your ladyship doesn't mind, at what Rule 43 says, because it may just assist me to explain.
Yep.
So it's at tab 4. It's page 32. I don't think it is page. It's tab 30. It's tab 4 of my manual bundle.
I haven't got tabs, so what number is it?
32.
It should be, but I think it's page 32 in my physical bundle. It's page 32
of the supplemental tab 3.
24. It's page 24.
Unfortunately, my bundle isn't numbered either.
It should be so you don't have tabs.
Are we looking at the authorities bundle?
Yes, in the authorities.
Yeah,
bundle.
I've got no tabs and I've got no numbering.
I'm very sorry to hear that.
I've got a few numbers. This one doesn't have number 32 in it.
Is it
It's
in the
about
centre of
a
the box?
quarter of the way through the bundle,
Right, thank you.
and it's in a different
Oh, I've got it.
different
Yeah,
font
I've got it.
from
Thank you.
other things.
Thank you.
It's Rule 43.
Yeah.
The upper tribunal may set aside a decision which disposes of proceedings or part of such a decision and remake the decision or the relevant part of it if the upper tribunal considers it's in the interest of justice to do so and one or more of the conditions in paragraph 2 are satisfied. In paragraph 2, the conditions are, and then the one we're concerned with is there has been some other procedural irregularity in the proceedings.
Yeah.
Now, in EP Albania, it was common ground that could include an unfair decision to dispense with an oral hearing. And indeed, the Court of Appeal more accepted that effectively in the case of GA and Hussein. And
GA wasn't really dealing with EP Albania.
It may not have dealt with whether this fell precisely with, but it was.
We didn't need to. We were just looking at whether there had been any unfair procedure which engaged
that's
issues of law.
So, but in any event, it was common ground that would include an unfair refusal to hold an oral hearing. And a challenge to that decision would be that the conclusion of the court as it was in EP Albania, that there had been no unfairness in the substantive proceedings, was wrong, and that the decision should be set, and that the tribunal should have set that decision aside. It was wrong as a matter of principle, and of course fairness is an issue that the court judges for itself.
Yeah, so the question still stands, and I'm sorry if I'm not being clear about it. That is going to a challenge to the substance, that it was unfair in the circumstances of this case not to have an oral hearing when things changed after the consent had been given.
Yes.
Yeah, okay. But that's going to the substance of the determination that was then made.
Yes.
And you attack the substance of the determination on the basis that certain findings were made, that the appellant in this case had no opportunity of correcting the
Yes.
misapprehension or in highlighting certain of the expert reports. All of that goes to substance. I'm wondering why it is that you distinguish that substantive challenge of the decision made against, as you said, the argument that you're now embarking upon, which is, can you independently challenge the fact that a Rule 43 determination has been made? It either has or it hasn't, but you're still left with the substance of the decision.
Well, my lady, I absolutely accept that a challenge to a refusal to set aside a substantive decision amounts to a challenge to the decision, to the decision, the original decision,
Yeah.
on that ground.
And that's
So
a
procedural-
conventional appeal, isn't it, from the decision that remains? Because the upper tribunal have refused to set it aside, so it remains, so
Yes.
you appeal to a higher authority the decision.
Well, you in this scenario, which isn't the one we have here, in this scenario there is a time issue, as there is in MO. And I am talking because it is difficult for me to make this submission properly because it's not the facts of this case. But in this scenario, there is some impediment to challenging the substantive decision, say a time issue.
Is there anything else other than a time issue?
Not that I'm aware. I'm not that I'm aware of. I don't know if there are maybe other impediments that may arise.
But you can think of none.
Well, I haven't done. I don't want to say that I can't think of any and suggest that I have exhaustively examined the possibilities that might arise by checking the legislation. Remembering, of course, that this is a set of rules and also a set of legislative provisions that apply right across a range of tribunals, not just the immigration tribunal. But in the immigration, what I can say is that insofar as I've thought about it, and I've tried to think about it in the other context, which is MO, it's going to be a time issue that would stop you being able to appeal the substantive appeal.
It would follow, I think, from your submission that if the upper tribunal were to set aside the decision under Rule 43,
Yes.
suppose your client had been successful,
Yes,
it would have been open to the Secretary of State to
to
appeal.
appeal. Yes, it does. And when we come to have a look at the legislation, I will be saying that that is one reason why this court might very well find that there is jurisdiction, because it would be it would be surprising if there was not a right of appeal against a decision that had consequences like that. And it's not just the Secretary of State. Of course, the appellant could have won the appeal, and the Secretary of State could apply to set it aside. Remembering this is an asylum and immigration jurisdiction, so it can concern matters like Article 2, Article 3, and
Yes,
and
but there
right
would
to-
then be if you set it aside, there would then be the right
There
to
would.
a rehearing
There would, but what?
with another right of appeal, because you're quite right to emphasise the importance of asylum and immigration and the potential consequences of bad decision making in that. But there's a difference between setting aside a decision and then having another decision in the upper tribunal, which itself can be reviewed on certain grounds by the Court of Appeal, and just setting aside and then you're living with a decision that is wrong.
Well, my lord, The Court of Appeal has said in FP Iran that all and this applies, of course, to substantive appeals as well, that the decision to set aside a positive conclusion in favour of an appellant for an error of law, or here for a procedural irregularity, is a decision of real magnitude for an individual who, even though it's going to be heard again, you are being deprived of something of real substance, notwithstanding that you would then get a new appeal. A tribunal has heard in your appeal and you have won. And the suggestion is that that can then be set aside. It is a substantial inroad into that individual's rights. Not least, of course, because what flows from it in time circumstances is that the person is entitled to refugee status or leave, and that would then be postponed.
But
so
if you then go back, but I understand that, I also accept that it is substantive in the sense that you have a position. But if you go back, have a hearing, lose, you can then seek permission to appeal on the basis that they should never have been messing around with it in the Rule 43 proceedings. And that would put you back. What concerns, so that you can deal with it fairly, concerns me about the proposition that you should have a freestanding right against Rule 43. If it is, as the textbook writers say, a quick and messy remedy for just errors that have gone wrong, the idea that you then have rights of appeal on both sides up to the Court of Appeal together with the substantive one is just going to lead to absolute chaos.
You mean separately to the substantive one?
Yeah.
Well, my lord, I'm going to come. I understand that there are policy reasons, both, or the policy points both ways.
Yeah.
And really, our submission on the statute is that the statute it's either there or it's either been excluded or it hasn't. But because there are policy reasons both ways. But all I'm saying is that it is a substantive and important decision for those involved. And to come back to my lady's question, the issue is, if you for some reason cannot appeal the original appeal for time reasons, you still have and you're in time to challenge the refusal to set aside. That would still mechanically achieve the same outcome for you of ensuring the set aside of that particular decision.
And this is very simplistic, but may I just propose the following set of facts? You're out of time to make a substantive appeal for whatever reason, good, bad or indifferent. And somebody says, well, I tell you what we can do. We can go back to the tribunal and say, because there's no limit of time, or that there is a limitation which can be extended in terms of time being extended to make the application, we're going to apply for the upper tribunal itself to set aside this particular part of the proceedings, the determination. And the upper tribunal says, well, we can see that you have got an argument that a document was not before the tribunal when it determined that you have or have not the right to stay. But we consider that taken proportionately, it is not in the interest of justice to set aside. So that's a determination, not specifically on the substance of the decision, but on the process that's been adopted. And my first question was all about this, and I'm sorry it was so clumsy. Do you say that it is possible for either side to come to this court and say that it was not a process correctly followed? And that if the tribunal, in the example I gave you, had actually given the weight that the document deserves, then there could be no issue but it would set aside. So it doesn't go to substance, it goes to the weight or whatever to be determined by the tribunal.
Well, my lady, that would be catered for by the restriction on the right of appeal to an error of law. You have to identify a right. Section 13 only permits an appeal on an error of law. So the reason that we are, so interests of justice, it would be, well, that may engage points of law,
So
but the
Rule
discretion.
43 and whether or not it's procedural or not, because it applies to procedural decisions.
It applies to decisions about procedural fairness and other. I mean, they're largely procedural fairness issues.
All right.
But the point that your ladyship has put to me, you know, an exercise of a discretion, weight given to a document, unless you could identify an error of law, you wouldn't be able to appeal anyway. So that you've got to be able to identify an error of law in the tribunal's approach on the Rule 43 in order to get permission to appeal in the first place. And that is the arguable error of law is what Lady Justice Elizabeth Lang has already found that she's already found there is one. So we have surpassed the threshold, which is it's a judicial review threshold, effectively, in relation to this decision. But not all challenges to that discretion would pass that threshold. It's certainly not an opportunity, and could never be, for this court to retake the whole merits-based exercise for itself. And of course, it's on very limited grounds. The difference between this Rule 43 set-aside power and the substantive appeal is that you can only apply to set aside on these bases. And they are important reflections of things having gone seriously wrong. As you will see, people not being present at the hearing for reasons that are obviously, and it would, you know, for reasons that were no fault of their own, and so on and so forth, and a procedural irregularity. So they are real flaws in the fairness of the process.
Procedural issues.
Procedural fairness issues.
Which sounds as though they are procedural decisions.
Well, I was going to come on to that. It may be that now would be the time for me to come on to whether they're excluded or not. My lord, I'm conscious that the bundle is, not everybody has tabs and page numbers, so but the place to start is at the start of the bundle, section 13.
Yeah.
Right to appeal to the Court of Appeal. And you'll see at 1, for the purposes of subsection 2, the reference to a right of appeal is to a right of appeal to the relevant appellate court on any point of law arising from a decision made by the upper tribunal other than an excluded decision. So that's the point of law restriction. Then you'll see any party to a case has a right of appeal subject to subsection 14, and that's a restriction on that the Lord Chancellor may make. And then at 4, permission or leave may be given by the upper tribunal or the relevant appellant court on an application by the party. And then turning over the page, an application falls within this subsection if the applicant. Sorry, that's the wrong. So for the purpose, it's 8. For the purposes of subsection 1, an excluded decision is. And then you'll see at C, the first thing that is excluded is any decision of the upper tribunal on an application under section 11(4)(b), application for permission or leave to appeal. Now, I should just make clear immediately there that is the application to the upper tribunal against a decision of the first tier tribunal. So that application for permission to appeal, the decision on it is an excluded decision. But
Which is why you have card.
which is why you have can't.
Yeah.
But what is not excluded is an application for permission to appeal to the upper tribunal, which we've just looked at section 13(4)(a). So that is not an excluded decision. An application for permission to appeal to this court is not excluded.
No, we know that, yeah.
And then at D, a decision of the upper tribunal under section 10, so that is a provision that's just, we'll have a brief look at it in a moment, to review or not to review an earlier decision of the tribunal, to take no action or not to take any particular action in the light of a review of an earlier decision of the tribunal, or to set aside an earlier decision of the tribunal. So those decisions are excluded. Now, notably, what is not excluded in that section, and that it must be deliberate, is not to set aside. So a decision to set aside is excluded, but a decision not to set aside is not excluded. And insofar as there's any doubt about whether it's deliberate, you can see that D1 excludes a decision of the upper tribunal to review or not to review. So if the legislator had wanted to say to set aside or not to set aside, they would have done. So a decision not to set aside under section 10 is not excluded. So we have two decisions, permission to appeal decision and a decision not to set aside, which are not excluded.
The section 10 review comes about when somebody applies for permission to appeal.
Yes.
And then the tribunal looks at its decision and says, oh golly, we did get that one wrong, and sets it aside.
Yes. Although it's on very restricted basis.
Now, fine. So let us suppose that your client applied, as he did, for permission to appeal. The upper tribunal looks at it, says, oh yes, we did. I'm sorry, we did have an unfair procedure. We will set aside the original decision. Secretary of State can't appeal.
No.
By contrast, if you apply under Rule 43 and the Rule 43 application is successful and the tribunal sets aside the decision under Rule 43, the Secretary of State can appeal.
Yes.
Why? What's the reason for that?
Well, my lord,
mismatch?
the restriction on this, at the moment I'm just going through the statute, and it may help to just finish doing that before I try to
Certainly.
put some sort of scheme together as to why the legislator may have done it this way. So we then have at E a decision of the upper tribunal that is set aside under section 10, including a decision set aside after proceedings on an appeal after this section have been begun. So you can't appeal the decision that has been set aside. It's not entirely clear why you'd want to do that, but in any event. And then any decision of the upper tribunal that is of a description specified in an order made by the Lord Chancellor. And this is what the Secretary of State relies on. And then at 9, a description may be specified under subsection 8F only if, in the case of a decision of that description, there is a right to appeal to a court from the decision, and that right is or includes something other than a right, however expressed, to appeal on any point of law arising from the decision. Or, and this is important in our case, B, decisions of that description are made in carrying out a function transferred under section 30 and prior to the transfer of the function under section 30 there was no right to appeal from decisions of that description. So the function, as we will see, is immigration and asylum appeals, which was transferred in 2010 to the upper tribunal. And the decision of that description is a set-aside on procedural irregularity, a set-aside decision. And the question is, was there a right of appeal? Was there no right of appeal against that decision? And it's only in that situation that you can exercise, if you're the Secretary of State, that power. Now, the explanatory note is over the page. And it refers to the two reasons.
I'm sorry to tell you this, but my copy of this explanatory note has been cut off. Quite apart from the fact that it's landscape, it's not complete. So, for instance, end of paragraph 114 says certain decisions are excluded to the same constraints as in section 11. And the first line of paragraph 115 says the power to add to the list of excluded decisions can be used for two where those rights are or include something other than a right. So I haven't got a complete copy of this.
Right.
Neither have I.
And you don't either.
Well, I've got the copy that my lord has, which I presume
My
is
lord.
in everyone else's paper bundles.
Well,
What-
I can only apologise for that, but
There was no electronic bundle of authorities, was there?
Yes, there should be. That was
there should be an electronic bundle of authorities that was sent through yesterday. It was sent through. Can you tell me when?
last week, last Tuesday.
Last Tuesday. But I can just read it out to you for now, and I do apologise. Paragraph 115. Well, paragraph 114 describes this power, and the general section, the scope of section 13 in terms of providing exclusions from appeal. And then it talks about how the Lord Chancellor can add to the list, but subject to constraints. And the constraints are, as is described, as a result, the power to add to the list of excluded decisions can be used for two purposes only. The first purpose is the preservation of existing appeal rights, and that doesn't apply here. That's the purpose at 9A. And the second purpose is the preservation, in cases where there is currently no appeal right, of the existing position. So you've got to be preserving the status quo. That's what that one is for. It's preserving a position where there is no right of appeal. And just to explain in this particular context, and I will try to endeavour to get these provisions to you, but this is the structure of the Tribunal Courts and Enforcement Act is different from the appellate structure that preceded it. So under the appellate structure that preceded it, you had a right of appeal only against a determination. You didn't have a right of appeal against interlocutory decisions.
So is that in the authorities bundle or still to come?
That's, I'm afraid, still to come. So the structure is different here, which is that you have a general right of appeal against decisions. This is under the Tribunal Courts and Enforcement Act, which applies to multiple tribunals. And then you have exclusions from that right of appeal. So it's a different way of approaching it.
Can I just ask why it wasn't thought necessary to put this in the bundle? Because it is actually helpful to follow an argument, to have it before you.
I can only apologise for that. So we have so when this explanatory note and section 13 F and 9 and section 13.8F and section 13.9B talks about the previous position prior to the transfer of the function. It's talking about preserving a status quo of no right of appeal. And so that is why it is important, before exercising that power, to know whether there was a situation where that type of decision was not amenable to appeal. And
Is there a
and-
part in your skeleton argument that refers to this that we can cross-reference?
Yes. So the skeleton argument that deals with this.
Paragraph 25. Following.
There's a paragraph. Yes, paragraph 25.
Thank you.
Well, it starts at paragraph 24. Well, the previous two paragraphs are the paragraphs I've just taken you through. And the transfer order that is referred to there. The thing that transfer order is in the bundle. The thing that isn't in the bundle is the pre-existing, that structural point about how the appeal power worked. And you can see at paragraph 24.
So it's really all in paragraph 26, is it? And I think the logic, if I got this right, goes like this. A refusal by the AIT to set aside was not a decision against which there was no right of appeal because there was no power equivalent to Rule 43.
Yes. So, having looked at the explanatory note and having looked at section 13.8, section 13.9b, the purpose of it was to preserve a position. And the Lord Chancellor was empowered to preserve a pre-existing position.
So by giving the upper tribunal a broader power,
an extra power,
under Rule 43, the right of appeal against that extra power could not be the subject of intra vares regulations made under section 13.8f.
yes, because it didn't. There was nothing that was being preserved. And of course, if Parliament, I've already showed you that Parliament looked at the review powers and made express provision to exclude the Section 10 power, the exercise of the Section 10 power, but has not done that for the Rule 43 set-aside power, which derives from the schedule to this Act. And so just moving on in this statute, section 22 provides at section 22.1, there are to be rules to be called the tribunal procedure rules governing the practice and procedure to be followed in the upper tribunal, that's B. They're then to be made by the Tribunal Procedure Committee at 22.3 in Schedule 5. Part 1 makes further provision about the content of tribunal procedure rules. And we then see at the back of this legislative clip, paragraph 15, at 15.2, rules may make provision.
Sorry, can you help me with this? When you say the back of this legislative clip, what page are we on now?
Well, I'm just, it's at the back of tab 1, but I'm conscious you don't have that tab. So I'm just trying, it's before the Social Security Commissioner's Procedure Regulations.
It's actually on page 16, although the pages aren't numbered, according to the index, that is.
Page 16. Yes, it's page 16.
So is this, well, we don't have a number, so is it headed Schedule 5 Procedure and First Tier Tribunal and Upper Tribunal?
That's right, and then paragraph 15 underneath.
Yeah, okay.
So 15.2d. Rules may make provision for the setting aside of a decision. So this is what you then see in Rule 43. So this is provided for in the Act.
I assume, is this right, that there is an equivalent power for the first tier? Because Rule 43 is only the upper tribunal.
There is an equivalent power for the first tier, yes. So that is where the power comes from, and it's not in dispute between the parties that there was previously no power to set aside on a tribunal decision. And so in my respectful submission, we're going to look at the regulation itself, the order. But in my respectful submission, that means that it is not possible, it was not possible, this regulation can't be construed in that way, to exclude decisions, a right of appeal against decisions of this nature. But my lord, even if, and I haven't, we've not pleaded it as an ultra vires issue, because we're simply, I mean, we're saying this could never have fallen within this category that is subsequently proscribed in the order in any event. But it's a piece of secondary legislation. It has to be read according to the vires of the Act. So just looking then, so that's the primary argument, that it plainly hasn't been excluded, nor could it be excluded.
So where do we get the common ground in relation to what was before the transfer?
It's in the Secretary of State's skeleton argument.
Because there were some rights in some tribunals to set aside on certain grounds.
Well, there is not an exhaustive analysis in this, in either of our skeleton arguments or in the legislation before you of what the position was in other tribunals. It's true that the Secretary of State has relied on the position in front of the Social Security Tribunal, but actually what the Secretary of State has said about that is not quite accurate. I'll explain that, but in any event, it doesn't matter, because it doesn't relate to this function. This function is asylum and immigration. That function is Social Security law. So when you're looking at section 13(9)(b), you're only looking at the function that is transferred when you're construing what preservation of the previous position would be. So it's the preservation of the previous position before that tribunal. And in my respectful submission, it's not at all surprising that you might do. It's not clear that you do, but that you might have different positions in different tribunals. What Parliament was doing, and you can see this explained in the Cart decision, is trying to provide an overarching structure to accommodate all sorts of appeals from different tribunals, which had different approaches. And so it's not a surprising conclusion if, in preserving certain aspects of that pre-existing scheme, you end up with different approaches in different tribunals. And the common ground is at paragraph 18
of the Secretary of State.
of the Secretary of State's skeleton argument. Sorry, it's actually in 17, the end of 17 as well. The respondent agrees with the contents of paragraph 25 of the appellant's skeleton argument insofar as it describes the powers of the former AIT under its procedural rules. And it says the historical absence of express procedural powers of review is also the subject of discussion by the upper tribunal in Jan. But then the Secretary of State goes on, in my respectful submission, to misunderstand 13(9)(b). It's not about removing rights of appeal which previously existed. It's about preserving a position where there was no right of appeal. That's what section 9(b) is about. So that. So, my lord, in my submission, that's the first point. It's not been excluded, and it couldn't be. But even if it were possible to exclude it, the question then arises: has it been? And that's the appeals excluded decisions order. And that should be page 27 if you have any pagination, or after the tribunal rules in your authorities bundle. And once again, I do apologise for the lack of any pagination or tabs. It's two pages.
Yeah.
And the passage that is relied on, or the provision that is relied on in the order, is 3M. Any procedural, ancillary, or preliminary decision made in relation to an appeal. And my lord, it's the appellant's case that this is not any of those things. And this, for your reference, it's dealt with in our skeleton argument at paragraphs 27 to 29. Now, my lord, just on the question of whether it's procedural, in my respectful submission, it isn't procedural for the simple reason that it doesn't relate to the setting of a procedure, the choice of a procedure before the tribunal. In my respectful submission, a procedural decision, as ordinarily understood, is a decision as to what procedure you're going to follow, something to do with the procedure.
So in this case, aren't you complaining that they decided to go ahead with a hearing on the papers? Isn't that a procedural decision?
Absolutely. A decision not to hold an oral hearing, a decision whether or not to hold an oral hearing is a procedural decision.
Yeah.
But a decision as to whether you've acted on, a tribunal has acted unfairly, and therefore the decision that they took should be set aside, is not, in my respectful submission, a procedural decision. So, for example, if this court...
But isn't this, I mean, EP Albania, and upon which you say you rely,
yes,
is subsection D, 2D, isn't it? Which is procedural unfairness.
It's procedural unfairness. The argument is that it
says procedural unfairness.
Yes, it does. But procedural, when you're, for example, if this court were to hear an appeal that a decision of the High Court or the upper tribunal was vitiated by procedural unfairness, and this court is hearing under ground for it, it's been conceded, but it is hearing that appeal, that it was vitiated by procedural unfairness, that doesn't make this court's decision a procedural decision. This court's decision is a substantive decision as to whether the decision below is vitiated by procedural unfairness. And that would be the case if you were looking at any case management decision taken below which had the impact of vitiating the substantive proceedings. So a refusal to adjourn is a procedural decision, but it usually challenged by ultimately when the appeal comes against the substantive conclusion of the whatever court it is, this court will decide whether or not it was fair or not, and that this court's decision is not a procedural decision.
But
so equally,
you're looking at the decision, you say,
yes,
not to adjourn, not at the time that the decision is made, but only when the decision is promulgated subsequently.
That's right.
Having not adjourned. So you then attack the decision that was made subsequently, saying,
Yes.
well, if there'd been an adjournment, we wouldn't have got to this place
Yes.
because A, B, and C would have been done in the adjournment.
That's right. So you're attacking the substantive. This is a power to set aside not just the decision not to hold an oral hearing, but the whole determination. So the Rule 43 power is a decision to set aside the determination. It's a ground, effectively a narrow ground, which could also be brought as part of the substantive appeal, which is why I say all of the reasoning has to be considered together. It's a narrow ground on this statutory scheme, which permits, unusually, the tribunal to set its own decision aside, having taken it, because that's not normal. This is what my Lord Justice Dingemans says, not normal for a tribunal to be able to reach a decision and then say, oh, sorry, I've made a mistake, and set it aside. Usually you have to appeal and have that question decided elsewhere. So here, the tribunal can set it aside itself on that narrow ground, but it's still a substantive decision, not a procedural. Sorry.
If you're looking at a review under Section 10,
Yes.
it's preceded by an application for permission to appeal
Yes.
on a point of law, and that could be you've misinterpreted one of the provisions of the Immigration Act, for instance.
Yes.
And if, on the other hand, you are applying under Rule 43, you are only able to do so on procedural grounds. You couldn't, on a Rule 43 application, say you failed to interpret the immigration laws correctly.
Yes.
So it's all about procedure. The whole thing is about procedure.
Well, it's all about procedure, but it's about the fairness of the procedure. So every one of those set-aside criteria relates to fair. You know, there are specified bases on which
Yes.
an appeal might be found to be unfair, and you can then set aside the whole appeal. And my submission is simply, you can't decide whether a decision is procedural or not because of the topic on which you are arguing the decision should be set aside. A procedural decision has got to be a decision about what procedure to follow. That would be the ordinary interpretation of this order, because otherwise, this court's just. Let's imagine that this was the only ground of appeal to this court was procedural unfairness. That this court's decision could be described as a procedural decision, but it's not a procedural decision. It's a substantive decision to allow an appeal and set it aside, which is what you do when an appeal has been allowed ordinarily, on the grounds of procedural unfairness. A procedural decision, as understood just on the ordinary language, is a decision about what procedure is followed in the proceedings.
It's a procedural decision is one that is a future-looking decision in order to be procedural?
It would be a decision about the procedure to be adopted in the proceedings.
But Rule 43 looks backwards.
Yes.
It says, this didn't happen. A document has now been produced that wasn't before the tribunal that made the decision.
Yes.
And on that basis, we say we set aside.
Yes.
It hasn't gone into the merits of what's in the document necessarily.
No.
Save it may do if it says, but this document that wasn't before the decision maker, in fact, concerns a shopping list about what's to be bought from Waitrose that day or wherever. So that's the interest of justice.
Yes.
But it doesn't say what is to be adopted going forward. It looks at what happened going backwards, doesn't it?
Yes, it's looking at whether it would effectively it's very unlikely that the court would decide to set aside a decision because a wholly irrelevant document wasn't produced. It would be one that had a material. It was unfair, basically. It's all about fairness.
Made a material difference, or could have made a material difference,
so that it would have been unfair.
Yes.
And in my respectful submission, a decision to set aside a whole determination based on issues of procedural unfairness is not a procedural decision. It's a substantive decision, just as this court's would be or any court. And so so it falls outside the ordinary meaning of 3M of the IDO order.
Yeah.
And of course, when you look at procedural, ancillary, and preliminary altogether, that argument becomes even stronger. These are matters that are obviously to do with the conduct of the proceedings. The interlocutory, what would ordinarily be expected to be interlocutory decisions, which would normally be challenged. You can see why the previous position was you couldn't challenge them. You only challenged, in this particular jurisdiction, the final determination of the appellate tribunal. And then any of those decisions along the way that had an impact, you would challenge them via that final appeal. So those are the procedural, ancillary, and preliminary, the types of decisions that would be excluded. This, on the other hand, is it's the tribunal deciding for itself after the determination has been reached to set it aside on a substantive issue of fairness, as it were. It's a fairness issue. So it's a conclusion that it's been vitiated effectively by procedural unfairness.
Well, I think we've got that point now.
So I'm sorry if I'm repeating it. So in my respectful submission, this is obviously not a procedural decision. Now, there is an authority that was referred to in the skeleton and is not in the bundle. And if I could hand that up, and I will at the same time hand up a provision of the upper tribunal rules, which my learned friend would like to rely on, which is also in his skeleton argument, but not in the bundle.
There was a certificate
Yes.
of compliance with Practice Direction 52C, paragraph 29, which both sides counsel subscribe to. So far, we've had 4 things identified as missing from the authorities bundle.
Well, I think yes, I think there may have been an excessive desire to keep to the 10 authorities, almost sort of a low number of authorities, and certain things have not made their way in, so I apologise for that.
Anyway, you want to hand up a decision.
A decision called Abiat, which really says...
Abias, you say this is referred to in your skeleton?
Abiat is in our skeleton. I'm also just going to hand up...
Paragraph?
It's paragraph 27.
Right. And then we've got you're also handing up a portion of the rules that
This is
Mr.
on
Harlan
behalf of my learned friend.
Yes.
Thank you very much.
Right. So this
And
is
you'll
decision
see,
of Mr.
this is, I mean, it's the tribunal saying really the same thing at paragraph 21. You can see it's sidelined.
Yes.
And my lord, there is an authority which is in the bundle. It's tab 11, and it should have a number of 66 on it. It's VOM, VOM.
Well, it doesn't, but VOM is in the authorities bundle.
Yes, in the authorities bundle.
It doesn't have a number on it.
No, I'm
So it's after Jan
it's after Jan.
and before AVB.
And it's really paragraph 32. I mean, VOM was about, and I think as my Lord Justice Dingemans already identified, it was about error of law decisions made en route to the final determination.
A remaking, whether in the upper tribunal or omitted. Yeah.
Yes. But paragraph 32, so the first reason that the court gave for, the tribunal gave rather for concluding that it wasn't appealable, the error of law stages, it wasn't a concrete decision, it hadn't crystallised as a decision at all. But it then went on to say, paragraph 32, that the decision on the error of law was part, and if I could just ask you to read that paragraph.
Conclusions are against you.
Well, my lady, the decision, my lady, are you thinking if there had been a decision to set aside?
Well, it just appears to me that paragraphs 33 and 34 are against you, but you're taking us to paragraph 32.
Yes, 32. It's really about whether it constitutes a procedural and ancillary preliminary decision. These are decisions along the way, effectively, part of the procedure. They don't finally determine the merits of the appeal, as at paragraph 32. They are ancillary because they provide necessary support to the prime task of deciding an appeal. That's not the case here. This is an after-the-event assessment of whether the whole determination should be set aside.
At the heart of your argument is that whether a decision under Rule 43 is or is not procedural depends on which way the decision goes. If it sets aside, it's procedural, and if it doesn't, it's not.
Well, no, my lord. I mean, if it sets it aside, it would be like allowing an appeal. It would have the equivalent status of allowing an appeal. It would be sent back, and it would have to be reheard.
It would be a procedural decision because it didn't finally determine the merits of the asylum application or whatever it was.
Well, it does finally determine the merits of that appeal. It's an appeal against. It finally determines the question of whether that decision is correct or not. So by this point you've had your final determination, which was the decision before the upper tribunal, and you are now en route to the Court of Appeal. But instead, well, if you get permission, but instead of going to the Court of Appeal, the tribunal steps in and does the job itself that the Court of Appeal could do. And sets it aside. And in my respectful submission, that cannot be said to be procedural, ancillary, or preliminary. So, my lord, just one point about the social security regulations that my learned friend relied on. They are in the bundle, just after paragraph 15, which you may have
Yeah.
marked up.
Regulation 31.
Yes. Now, in my learned friend's skeleton argument, there was a suggestion that in that context, there had been a right to set aside, which there wasn't in the Asylum and Immigration Tribunal context, and that there was no right of appeal against it. You see that over the page at Regulation 32. But in fact, at the material time, which is just prior to the transfer of responsibility to the tribunal structure, that basis for set aside had been removed or revoked. You can see that at 31.1, and then it should have been 31.1c, and it was revoked. So even if it were relevant, which I've already made the submission that it isn't, because it's what the part of the statute looks like is that particular function, which is immigration and asylum, the argument doesn't work for this particular tribunal. And what I haven't done is look at other tribunals, but because it doesn't, in my respectful submission, it's not relevant anyway, but it doesn't work in relation to this tribunal. Now, I said I would
Well, I don't think
address
3M doesn't necessarily exclude all procedural decisions, because it applies, 3M only applies in the immigration context, doesn't it?
Well, it's appeals. I don't think that's right.
No.
It applies across the board. I think the appeals excluded decisions order, but I will just double
Any
check.
procedural, ancillary or preliminary decision
Oh, I
in
see.
relation
Yes,
to
in
an
the
appeal.
nationality.
Yeah.
That is correct. So it doesn't apply to that anyway. Yes.
I should just say the OM was referred to in Tazagi in the Court of Appeal and explained at paragraph 40. Not in any way that affects your argument, just so that you both know that.
It's been, the reasoning has been more or less
Approved,
endorsed in
yeah.
the Court of Appeal. Yes. We have referred to that in our skeleton argument, but I think because of trying not to cite too many.
No,
authorities, I'm not
absolutely right.
So I said I would come at the end to talk about possible policy reasons as to why Parliament might have taken this approach. And there are 2 points that I would like to make about that. The first is, as I said when I was going through the statute to begin with, the permission to appeal decision is not excluded. The refusal to set aside is not excluded, and the set aside decision is not excluded. And in my respectful submission, all of those decisions are matters that will come before the court, are likely to come before the court anyway in the substantive appeal. They are going to be considered as part of when the Court of Appeal decides whether to grant permission, and if so, what conclusion to draw. And in my respectful submission, what is anticipated, as I say, it's going to be a very unusual case where you need an independent Rule 43 decision, conclusion, because one of the things we didn't look at is the time limit on it. The time limit in the rules
They seem quite similar.
is the same. It's a month.
Mm.
And so ordinarily you would be out of time. If you're out of time for your permission to appeal decision, you'd also be out of time for your Rule 43 decision.
That's why I wasn't quite understanding your point about you might be out of time for one but not for the other.
Well, because as happened in MO and in EP Albania, in a number of cases, the tribunal extended time. So it's a very unusual situation that has arisen, because what happened is that some people and not others had their determinations decided on the papers early on in this unlawful procedure. They then appealed.
Yeah.
There was then a challenge heard to the procedure, which was the JCWI case. The challenge was ultimately successful. While that challenge was going on, other appeals were also being heard or determined on the papers. Some people ended up in a position, therefore, when the challenge succeeded, some people had outstanding rights of appeal to the tribunal. And this is one example of that. Some people had not appealed.
Yeah. So the upper tribunal has power to extend time
Yes.
for making an application under Rule 43,
Yes.
but no power to extend time for appeal? Or it does have power
Well,
to extend time
in
for
this
appeal
case,
as well?
in this case, in some cases, it had refused. So in MO, it had refused before the JCWI judgment had come out. It had refused the permission to appeal, and for reasons that I actually can't, that will become clear in that other case. Some people did not appeal, did not renew their application to the Court of Appeal in time. So they ended up in a situation where they had not renewed their application for permission to appeal on those particular grounds. The JCWI judgment then came out. They, along with others, applied under Rule 43 to set the determinations aside. The tribunal extended time in all of the cases that needed time extended in EP Albania from the determination in JCWI. So in that very unusual situation, people were in the position where some people, very few in fact, not this appellant, were in the position where they were out of time for renewing their application for permission to appeal to the Court of Appeal, but they were in time to make a challenge to the Rule 43 decision. And so ordinarily this situation would never arise. But the reason why it's important to see that the decisions on set-aside review and permission to appeal are not excluded is partly because of the argument, my Route 1 argument that I made at the start. In my respectful submission, Parliament anticipated that this court would be looking at all those decisions alongside a substantive decision on an appeal. That's what Parliament that's what it would normally be doing. It wouldn't need to look at the decision to set aside following a Section 10 review because that wouldn't be before it. But it would need to look at the decision not to set aside. And it would need to look at a decision not to set aside a Rule 43 determination, and also a decision to refuse permission to appeal, all as part of a composite set of arguments as to why the tribunal had gone wrong in a range of respects. And that, of course, will have and this leads on to my second policy argument.
Before you go there,
Oh, yes.
so are you suggesting that the Rule 43 avenue is a fail-safe device for those who miss the boat in relation to an appeal against the substantive decision? Because if they are in time to make an application for permission to appeal against the substantive decision, presumably they would take it.
Yes.
And the only reason not to do so, and not to burden this court, is because they can persuade the upper tribunal that what is being alleged is that the decision may be the same, but the process will be different because we've now got a witness who can come along, or we've now got a document that wasn't before the court. Now, if that's put before the upper tribunal and the upper tribunal says, well, we refuse to exercise our power under Rule 43 to set aside, you would then go to the Court of Appeal, presumably, and say, well, we are out of time, but this is because we've tried to exhaust our remedies before the upper tribunal. And what we want to appeal is not the fact that the upper tribunal refused, but the decision that they came to in the first place.
Well,
It's a method, in other words, of substantiating a late application for permission to appeal, because this court has got the power to extend time.
yes. Well, My lady, this court does have the power to extend time on a late application for substantive permission to appeal. And it could do that.
So what's the difference?
Well, the reason that I'm hesitating is that this doesn't arise in this case, and as
I think we're being asked to decide a point of principle.
well, that's right. But there's that situation. I mean, I've just described the kind of range of situations that have arisen, which are not. I mean, insofar as there's any sort of attempt to abuse these powers that's being suggested, that's not what's gone on in MO. In MO, sorry, not in MO, in EP Albania, in that suite of situations, that series of situations, something happened in the middle of it, which changed the position.
But it seems to be that
Yes.
EP decides that the only time that Rule 43 could not be used by the tribunal, if they decide to extend time, is if the Court of Appeal is actually seized of the matter. In which case it would be quite improper.
Well, in fact, the Court of Appeal was seized of the matter in many of the appeals. There were
Wasn't it just
applications
at the
for
permission stage?
At the permission stage, yes.
No, I'm talking about being actually seized of the matter in
Yes.
terms of having permission granted and about to embark upon an appeal.
Well, I mean, sorry, I may not have entirely understood the question, and I apologise for that. So if the Court of Appeal was seized of a substantive appeal, then the jurisdiction of the tribunal would be spent. You couldn't go back to the tribunal on a Rule 43.
I appreciate that,
Yes.
Miss Kilroy. The question started off as you seem to be suggesting that Rule 43 may come into its own if time has elapsed for an application for permission to appeal the substantive decision has elapsed.
Yes.
I put to you that this court can extend time
Yes.
in which to make the application.
Yes.
It will need proper reasons.
Of course.
But one of the reasons that may be put forward is that the upper tribunal declined to exercise its power under Rule 43 to set aside because it was not satisfied of any of the particular grounds.
Mm-hmm.
The point then is you come to this court seeking permission to appeal out of time against the substantive order, because otherwise what you're doing is getting an advantage time-wise by saying, no, we're coming to actually appeal the refusal to exercise the power under Rule 43.
Yes. Well, my lady, on every application that is made to the Court of Appeal for permission, there is a discretionary right to refuse, including because the other opportunities may have been available. I mean, in this case, the permission has been granted by one route or the other.
I won't detain you any further, Miss Kilroy. We're obviously at cross purposes.
Well, I do apologise if I'm not properly addressing the point.
I'm
that
sure
you
it's
raised.
me. Sure it's me.
But my general point is that this is a jurisdiction that is very unlikely anyway to arise in most cases. And obviously where there is a situation where it may arise, and I'm not arguing that this is what Parliament had in mind.
This is meeting a floodgates type argument, is it?
Yes, I'm not arguing. Well, yes, exactly. I'm not arguing that Parliament had this in mind. I'm not suggesting Parliament created the possibility of a Rule 43 in order to allow people to evade the time limits for normal applications for permission to appeal. I'm looking at the statute and saying these decisions were not excluded.
Yeah.
Why not? and
You're going to go on to a second policy reason.
And the second policy reason is judicial review, because as these cases demonstrate, the EP Albania decision was, what the tribunal did there was to collect together a range of appeals to give guidance on how to exercise the Rule 43 power in other appeals. You can see that from EP Albania.
Well, I might have been able to if you provided me with a copy of it.
I'm very sorry about that. And you can see I hope that you've got a copy now.
I think they're behind you.
I'm so sorry. I thought that was I was under the impression it had already been handed up. Thank you. Yes, so it's at paragraph 5
yes.
of this determination, and you'll see the court explaining the history.
Yes.
And then you'll see at the top of page 5, some 80 applications under Rule 43 being received. While such applications would ordinarily be considered on the papers, we've heard 18 such applications with the intention both of determining each Rule 43 application and deciding various issues common to these applications and which are likely to inform the outcome in other Rule 43 applications which for now have been stayed.
Yes.
So the purpose of this judgment, or series of judgments in 18 cases, was to provide guidance. And in my respectful submission, that is quintessentially the type of judgment on which a challenge ought to be available. It's giving guidance on the exercise of the Rule 43 power, and in this particular situation, or generally. And if there is no right of appeal to this court, then that is the sort of judgment that would be amenable to judicial review. I mean, there must be a right of challenge somewhere if the tribunal is getting it wrong. Now, my learned friend has relied on CART as suggesting there would be some sort of barrier to judicial review. I don't think that is right. It may be that that could be argued, but the CART is about applications for permission to appeal from the first tier tribunal to the upper tribunal. It's not about this situation, and it doesn't set that second appeals criteria limit in this particular circumstance. So as things stand, you would have a right of a right to challenge the decision by way of judicial review if you didn't have a right of appeal in the ordinary way. And in my respectful submission, much better to have, in terms of policy reasons, to have a right of appeal to the Court of Appeal, subject to a requirement of permission in the ordinary way, with discretionary decisions available as to whether someone has, unjustifiably failed to appeal the substantive decision and is now seeking to evade that in some different way. That will all be part of this court's assessment of whether to grant permission in any event.
Can I suggest to you one reason why that might not be right,
Yes.
which is that if Rule 43 is just to put things right in a sort of summary and slightly messy way in tribunals, fine, leave that to the tribunals, because you've always got the right to appeal on a point of law to the Court of Appeal. And what is then a procedural matter, a bit like case management, the Court of Appeal is not going to mess around with any decisions on case management, and principles to be applied by Rule 43 are for the tribunal.
Well, my lord, the principles these are not case, first of all, case management decisions that have serious consequences.
But they've still got the right of appeal.
They do have the right of appeal. I mean, it may be that this just goes back to the point about how this issue can be considered as part of the right of appeal in any event. It's part of the why it hasn't been, in my respectful submission, obviously hasn't been excluded by the statute, and will be considered by this court as part of its ordinary the ordinary mechanism of examining a substantive appeal. And so the question arises, in my respectful submission, is in the very unusual situation where there is some reason for or some circumstance in which the tribunal decides to hear a Rule 43 application, or considers a Rule 43 application out of time, extends time for it, even though it's out of time, and then someone appeals against that decision. What is the policy reason why that should not be subject to to a right of appeal? And in my respectful submission, it is better for this. If I mean, what we're doing really is just examining reasons why Parliament might have left this decision amenable to a right of appeal. It's not for us to determine what the policy position is. It either is or it isn't excluded. But what is the possible policy basis for interpreting it one way or another?
Right. What is the policy basis, assuming that Parliament consciously decided not to exclude these decisions, which you say it probably didn't?
Well, because it was, first of all, the answer I've already given, don't want to repeat myself, that it's part of what Parliament anticipated would be coming before the court anyway. Yeah. But insofar as it was left untouched and might be exercised separately, it is that is likely to be a very rare situation, and when it happens, it's better that this court is seized of it than a court on judicial review, with all the restrictions, because of course once you come to this court, that's it. In a judicial review, you would then have a right to appeal. So it makes far more sense for this to be accommodated within the ordinary appeal structure. And in my respectful submission, that is what it is. And it may be that some cases are simple, as my Lord put it, dirty, quick and dirty.
Well, that was from the textbook.
From the textbook. From the textbook. It may be that is, but some aren't. And in those situations, the question is what is the proper way to approach reviewing them?
Yeah.
May I just ask, Ms.
Yes.
Gilroy, you say that it's right for this case to come here because EP Albania purported to give guidance. What guidance did they give that you seek to challenge?
Well, in this case, the court said that if a party had consented to a paper determination, and this is at paragraph 62, it might be worth looking at it so that you know what the issue is. So these were generic. The first section of this judgment provides generic guidance on how to approach the Rule 43 applications in this context.
I understand.
And at paragraph 62, although the Rule 34 decision is for the tribunal, not for the parties, I should start from the beginning. Rule 34.2 requires the tribunal to have regard to the views of the parties before deciding to make any decision without a hearing. We consider that where parties consent to a no-hearing determination, that will ordinarily provide strong support for the conclusion that the decision to proceed without a hearing was lawful. Although the Rule 34 decision is for the tribunal, not for the parties, I should pause there. It is the tribunal that's got to assess whether it's fair to proceed or not without a hearing. The parties to an error of law appeal will usually be well placed to assess whether, and if so, why a determination without a hearing would or might be unfair. Each party will know the nature of its own case. Each party will be able to assess from its own perspective the relative advantages and disadvantages of a no-hearing determination.
So do you take issue with any of that?
Yes.
But what part of it do you take issue with?
Well, this is what we've got permission on, which is that actually, as the facts of this case showed...
No. On this guidance, I've asked you to look
Each
at the...
party, not
the guidance.
each party will be able to assess from its own perspective the relative advantages and disadvantages of a no hearing determination.
Will usually be well placed. You see, what it didn't do was say in every case, and in circumstances where the Secretary of State didn't turn up at the first instance hearing, your side assumed the Secretary of State wasn't going to turn up at the second
Yes.
instance hearing. Well, then it's no surprise that you were quite happy with the paper determination, and that's why the judge said usually. So, I mean, it's not clear to me that you're actually challenging the guidance. What you're doing is saying that the judge shouldn't have applied it to your particular case, which is why Lady Justice Elizabeth Lane granted permission to appeal.
Well, yes. I mean, it may be that...
That doesn't seem to be the argument that was put. The argument that was put, which is summarised in 150, it was about the nature of the consent, reluctant consent. It wasn't put, well, we assumed that Secretary of State wasn't going to contest the appeal, and then when we realised that she was, it suddenly became unfair. That wasn't the argument that was put to the upper tribunal on this Rule 34 application. It may be the ground on which you have permission to appeal, but it doesn't appear to have been argued.
Well, my lord, I accept that it's not reflected here, but the point was that what the court then said is
Two submissions are generic, which they've dealt with that in the general guidance. And then the first submission is the nature of the consent. And they say that DJ was represented by solicitors and counsel, that the submission was clear, unconditional, and the gloss that they want to put on it is opportunistic. But there's nothing there to suggest that the real complaint was that the Secretary of State, that somehow DJ was misled by the non-appearance at the first hearing into thinking the Secretary of State wasn't going to contest the application or whatever.
Yes, well, it may be that argument was not properly articulated in front of the tribunal, but the point was that the tribunal had set out some guidance on consent, and the guidance, I accept that it says ordinarily, but it also made a comment about the position that parties were ordinarily in, and what this case exemplified on appeal, which is why permission to appeal was granted, is that actually it may not even ordinarily be the case that the parties are in the best position to make the judgment. And that's what the facts of this case demonstrate, because in fact, quite a lot happens, and this is what Lady Justice Elizabeth Lang appreciated in my respectful submission when she wrote the lengthy permission judgment. Quite a lot happens between the point at which, under that scheme, you were asked to set out your position as an appellant, and the point at which the judge decides whether to proceed without a hearing or not.
But the upper tribunal may have understood that argument if it had been put before them.
Well,
that's the whole point.
I think
so that if you could come to this court and say, this was the submission made to the upper tribunal, it wasn't anything to do with reluctant consent, it was, when we made our consent, it was on the mistaken belief that the Secretary of State was not going to attend or actively oppose. That would have been quite different to that which the upper tribunal summarised your position to be. And nowhere in your skeleton argument, that certainly that I've seen, or in the notice of appeal, even now does it say the upper tribunal completely misunderstood our case on this point.
Well, my lady, obviously the structure of this judgment was that generic arguments were considered first, and individual decisions were made, often without an awful lot of reason. You can see how short they were in the back.
But even short though they are, Miss Kilroy, you're now saying to this court in your submissions that that's got nothing to do with the price of butter, so far as this case is concerned, because it's not about reluctant consent. It's about the fact that consent was given for a situation that did not come to pass.
Well, my lord, my lady, what I was trying to say is that in the arguments that were put generically, because people were advancing arguments collectively as well as individually, the argument was put, not exactly as I recall, and I would have to go and check exactly how it was put, but the argument was generally put that the consent should not be, any consent should not be viewed as determinative for a range of reasons, including the existence of the presidential guidance note and other factors which I
It's
would...
not said in paragraph 62 to be determinative. It's said to ordinarily provide strong support, not to be determinative.
Yes, well,
So
I
it
think
all depends upon the facts.
but there was an argument that that was not right, that the consent, the argument that was put to the tribunal is that consent should not ordinarily, in this particular context of this particular procedure, should not ordinarily provide strong support. And there were arguments made, not, and I wasn't, I believe I wasn't making them because I was representing two individuals who had not consented expressly at that time. So I would have to check, but this was a generic argument that was run. And I accept that it doesn't appear in the specific arguments made in relation to this case. But my lady, I was showing you this judgment, not in relation to the facts of the appellant's case, but to illustrate that a judgment on Rule 43, especially a judgment like this that is intending to give guidance to others, can raise points of principle which will have wide implications for other individuals, which are amenable and ought to be capable, must be capable of challenge. And that's, I was giving this as an example.
That's why I asked you, Miss Kilroy, what particularly you took exception to in this guidance.
Yes, well,
and it's very difficult to understand, with the greatest of respect, why the tribunal were wrong to say that if they appear to have parties who have capacity, and in the case of your client, actually had representation from the start, that they should go, as it were, behind what appears to be consent.
yes.
But
Well,
you haven't pinpointed in this generic guidance what you say is wrong.
well, my lady, what I've tried to... may I just divide up the points that I'm making now? At the moment, we are simply looking at what the policy reason might be that it would be preferable to have an appeal as opposed to a judicial review. And the argument that I'm making is that as this judgment, this determination shows, and there are lots of other examples in the generic section, not just about consent, points of principle about how to approach the question of whether it's fair to dispense with an oral hearing are included in this judgment, and they need to, if they are wrong, they need to be challenged. Now, in this appeal, the appellant was also challenging the decision in his individual case and has got permission on the basis that the tribunal, both tribunals got it wrong on his facts. Now, if we had been arguing the main appeal, which we're not because, as I understand it, it's conceded that the tribunal should not have treated consent as determinative in this case, that it was unfair to dispense with an oral hearing. That is conceded. So we're not arguing it. But if we had been arguing it, one of the things that I'm likely to have been saying is that this would have provided a good example of why actually in the particular circumstances of this appeal, this procedure, that so much happened between the point at which the person may have given their consent, and not all did, and the hearing of the appeal, that in fact the judge was in the best position to judge whether it was fair, not the parties, because the judge would be seeing the arguments put by the Secretary of State, and the judge would also, sitting there, having considered the papers, know whether the things that were moving the judge in one way or another were things that needed to be put to the
I can
individual.
see the merit in those arguments.
Yes.
But usually they're arguments that have been determined by the first instance court upon which the appeal is based. And in this case, if you are effectively appealing EP Albania, the same arguments were not run before the upper tribunal as they are now being run before us.
Well, this is a question of law, whether it was fair or not. I accept that some of the way it's put in this particular case, some of these points were not drawn out. And there are lots of things that I could say about that.
It's not quite that.
Yes.
You want to challenge the decision by the upper tribunal not to exercise its power under Rule 34 to reopen the decision against your client.
Yes.
We would therefore have to consider upon what grounds were the upper tribunal asked to exercise the Rule 34 power, and the ground on which the upper tribunal apparently asked to exercise that power are not the grounds that are advanced in the skeleton argument that was put before Lady Justice Elizabeth Lang, as far as I can see. Is there any evidence to support that argument anywhere?
Well, my lord, can I just, the structure of the argument that was put before EP Albania, and I can dig that out, is that it was unfair to dispense with an oral hearing.
Well,
Remembering,
I'm fine with that.
full stop, it was unfair.
Yeah.
And this was an asylum case in which it was, the highest standards of procedural fairness applied, and the tribunal nonetheless made a decision to dispense with the oral hearing. The reasoning is non-existent, almost non-existent.
So are you saying that EP Albania was wrong not to decide that it is always unfair not to hold an oral hearing in the case of an asylum application?
Well, the submission would be that in an asylum and immigration, in an asylum case, which this is, raising Article 3 issues, it is the existence of consent at that early stage in the process cannot be said to be ordinarily indicative.
So paragraph 62 is wrong.
Yes, that would have, but my lord, I mean, I haven't come here to argue that argument today because it's not an issue between, as I understand it, between the parties. There's no contest to this part of the case. The Secretary of State has accepted that a hearing should have been held, which implicitly means that consent cannot have been determinative in this case, and so we're not looking at the general guidance at all. The reason we, as I understand it, are exploring this issue is because it comes up in relation to what the jurisdiction of this court would be.
Well, we're also exploring it to some extent on your first route to getting your costs, which is to say we must look at EP Albania as applied in your client's case when considering the substantive appeal against Upper Tribunal Judge McLennan. Well, now, if we are considering EP Albania as applied in your client's case, we would, I would suggest, be looking at the grounds upon which the Upper Tribunal was asked to exercise its Rule 43 power in your client's favour and the reasons it gave for not doing so.
Well, my lord, I
understand. As I've suggested to you, the reasons now being advanced in support of the appeal against the substantive decision by Judge McLennan bear little or no resemblance to the grounds that appear to have been advanced in front of the Upper Tribunal on the Rule 43 application. And I asked you, is there some evidence to support them?
Well, it's in the supplementary bundle 2.
Right.
But my lord, well, let me go to this and then explain. Page 99.
Supplementary bundle 2, yeah? Page.
That's my 99.
Further submissions following the judgment in EP Albania. Is that? Skeleton argument for hearing on.
So it's 95. I apologize.
Yeah, no,
I had
don't worry.
99. 95 paragraphs 11 to 12. So this was the skeleton argument that was run.
So this was before the upper tribunal on the
Yes,
Rule 43.
Because there was one hearing date and then it was adjourned.
it was adjourned, yes. And you'll see at 8 to 12 that the germs.
see.
So first was a belief that realistically he did not have much choice, which would fall under reluctant acceptance. Second, a desire to progress his appeal rather than to have to wait. Again, which perhaps goes to reluctant agreement. Third, good basis to believe that he had a strong prospect of success rather than it being finely balanced. And this was the final reason for accepting a paper determination.
So I think 11 does have the germs of what is now being put. He had already successfully appealed to the once before. This is on a previous occasion. The judge had, so this is a second appeal, had refused to accept the evidence of a corroborative witness and supportive expert report without any challenge from the Secretary of State, and without giving the witness or Mr. Janet a chance, I should say, at the hearing to respond to the criticisms contained in the determination. Permission had been granted to appeal the determination on all grounds. In the light of these factors, it would have been reasonable for Mr. Janet to be confident that a UT judge determining the appeal on the papers would be likely to grant the appeal. In the event, UTJ McClellan formed a different view of the strength of the appeal. Had there been an oral hearing, Mr. Janet's representative would have had the chance to appreciate this and dynamically engage with the judge.
That goes back to all the other arguments. The point is, on papers, Lady Justice Elizabeth Lang saw the strength of the points made
Yes.
and determined it. And bad luck, it didn't happen at the upper tribunal, and we will, as part of the order, put that right. That has nothing to do with having a rehearing before the upper tribunal. It didn't make it unfair to have the determination on paper. It just said the judge got it wrong on an occasion, which is why you have an appellate system.
Well,
And paragraph
no,
11.
it was unfair to have the oral. It was unfair to dispense with the oral hearing, without on the basis of first of all, I ought to show you just the reasoning. I mean, part of the problem with this is there's almost no reasoning.
We've seen the reasoning, yeah.
For
It's
dispensing.
150.
Can we just look before
Yes.
we do that? Page 99, this is what goes before the upper tribunal, says that he'd already had a successful appeal, he got permission, he'd been granted to appeal, and he's reasonably confident that an upper tribunal judge would grant the appeal. Compare that with paragraphs 67 on page 73, which majors on the fact that the Secretary of State decided to contest the appeal after the deadline had passed. Now that doesn't appear to be something that was relied on in front of the upper tribunal.
Well, it's not put as clearly as that, but it does say that the Secretary of State didn't object. In paragraph 11, the judge had refused to accept the evidence of a corroborative witness and supportive expert report. This is in front of the first-tier tribunal without any challenge from the Secretary of State. So there is.
Well, that was the first tier.
But
What we're talking about is the appeal to the upper tribunal.
Yes, so the point is not made here that subsequently to the application for permission to appeal, the Secretary of State for the first time put in submissions. I accept that that point is not made, but it's implicitly raised that the Secretary of State had not objected to the appeal in front of the first tier tribunal.
There's an awful lot of implicitness about these.
Well, listen,
I mean,
my lord, I
I'm
accept.
seriously saying that the upper tribunal ought to have teased this point out of what was put before them.
No, my lord, the structure of the argument was it is unfair to dispense with an oral hearing in this case because of the issues and the importance of the issues. That was the overall structure of the argument. And what was there was then an issue that had been raised in EP Albania about the significance of consent. This was a generic issue. That's why you see it dealt with in the generic section. What is the significance of consent? And the court, the tribunal sought to give guidance on what the significance of consent would be in this very particular context. And a range of arguments were put about the significance of consent in this particular context. And that one of them would have been that the tribunal would the tribunal was itself judging the fairness, and the backdrop to giving consent was the pandemic and the guidance which told people that they would have to produce there would have to be exceptional circumstances not to dispense with an oral hearing. And so that was the argument that was made about why it was wrong in this particular context to rely on consent when it had subsequently been established that that guidance was unlawful. And so that was the particular context in which it came in front of the tribunal. What then happened is that people made individual arguments about what had happened in their cases. And the courts have subsequently assessed that this whole question of whether you should be entitled to challenge or on what basis you might set aside the determination despite following JCWI, the courts have said that you should look at the facts of the individual case. And so that is what has happened to see whether it was fair in the individual case, notwithstanding that the guidance was unfair. What happened in the individual case, was it fair? And so what is now being what has been put in this appeal is that having given the consent, there were a range of things that subsequently occurred
Vitiated the consent.
that vitiated, that effectively, or at least should have led the tribunal, when examining it, to decide to re-examine the issue for itself. And so, I mean, that is the argument. It's not dealt with in the tribunal's general guidance, and in any event, it is conceded that it was a mistake not to hold a hearing in this particular case as a matter of law, because fairness is an issue of law. So I was raising the issue of the generic guidance, not because I'm asking you now to provide that generic guidance, because we're not having, I'm conscious at the time, we're not having an appeal on the merits, as I understand it, because there's no pleadings from the Secretary of State on the merits of this case. The Secretary of State has not not contested it, but has, in the statement of reasons, accepted that a hearing should have been held in this case. So we're not having that argument. I was showing you this judgment simply because it is an example of why a right of appeal should be construed off this legislation, or should be construed from this legislation. Otherwise, judicial review will have to fill the gap, because on any view, this is giving guidance. Now, it may be that having looked at the guidance, you think it's right, but that's not the point. The point here is, what if it were wrong?
Yes.
And we haven't looked at the whole of this guidance.
I understand.
So, my lord, I've taken too much of your time, and it's 1:05.
How much longer do you need, Ms. Kilroy?
Well, my lord, on the jurisdiction issue, I don't need any more time, but I do want to be sure that I haven't come here and I haven't even addressed you on the substantive issues, because there is no contest between the parties.
You mean the appeal against Judge McLennan?
Yes.
Yes, no, that's conceded.
And against EP Albania.
Well, I'm not sure about that, but...
Well, it is conceded that it was wrong to...
It's conceded that the hearing in front of Judge McLennan Should have been an oral hearing.
Should have been an oral hearing, and implicitly, therefore, that the tribunal should have set it aside.
That's where I'm not so sure, for the reasons that we've just been discussing.
Well, my lord, in that case, I will just reflect over lunch whether there is anything more I need to say to you about that.
All right, 2:05.